Need to go start there. Get bored. Oh, that's all right, Mr. Schmidt. Who are you ready on?
Roger Bridges.
Bridges. Yeah. This is cause number CR 24-299, State of Texas versus Roger Neal Bridges on the state's motion to adjudicate. Next time we'll have them go the other way. Next time we'll have them go that way when we have the public in here. We're gonna have them go that way. Go ahead. Announcement on motion to adjudicate.
Judge, we were asking for a reset on that. I think the state did you indict a new offense on Mr. Bridges? They just opened up the discovery for me to review. I think that's one of the bases for the motion. So we're gonna ask for one additional reset. In addition, we received an offer from the state yesterday. Need to sit down with Mr. Bridges to consider it.
Any objections from the state?
No objection, Your Honor. Thank you.
All right, court will set Mr. Bridges for May 28th.
Say May 28th?
May 28th. All right, and then cause number CR 24-183. In that case, you appeared before the court on September 24th of 2024, also on burglary of a habitation. Court followed an agreement that placed you on 5 years of deferred community supervision and alleged in a amended motion to adjudicate or revoke also 5 allegations. So he's pleading true to those 5 counts and that cause number as well, and also waiving the reading of that motion to adjudicate.
Yes, sir.
All right. And it appears in that case, as you were saying, Mr. Schmidt, that the agreement is upon its plea of true, that the amended motion, pleading true to the amended motion to adjudicate. Recommendation is defendant's guilt be adjudicated, community supervision be revoked, and punishment be assessed at 8 years confinement. The Texas Department of Criminal Justice for the balance of its financial obligations, which includes fines, court costs, and reimbursement fees. How much credit time would Mr. Jenkins be entitled to on that cost?
On the MTA, Judge,
I think they're both MTAs.
it shouldn't be. One of them is we're pleading to a lesser included. It was indicted as burglary of habitation, but it's actually a criminal trespass of habitation. So that one is a new offense. It should be a straight 34 days in the county jail with credit for 34 days. And then on the other one, he has, give me 1 second, I'll pull those. On the CR 24-183, you should have 338 days credit time.
338.
Yes, sir.
All right, Mr. Jenkins, is that your understanding of the plea agreement in both cases?
Yes.
All right, and the court will note that the cause number CR 24-183 is a motion to adjudicate, and CR 25-126 is a new offense. All right, then, Mr. Jenkins, at this time, I would ask you in cause number CR 24-183, how do you plead to counts 1 through 5? Are those counts true or not true?
True.
And has anyone threatened you, forced you, or pressured you to plead true to any of those counts?
No.
And cause number CR 25-126 on the charge of criminal trespass of habitation, how do you plead to that offense?
Guilty.
Are you pleading guilty because you are in fact guilty of committing that offense?
Yes.
Has anyone threatened you, forced you, or pressured you to plead guilty to that crime?
No.
All right, the court will accept the defendant's pleas of true and plea of guilty respectively in each cause. Mr. Smith, any objection to the evidence being admitted?
No objection.
Evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, in CR 25-126, state is in compliance. No communication was, no BIS was received from the.
Thank you. Anything further from the defense?
No, sir.
All right, the court's going to review the evidence. Court, having reviewed the evidence, finds enough evidence to convict the defendant in cause number CR 25-126. Court hereby follows the plea agreement in recommendation of the state. The court hereby convicts Isaac Anthony Jenkins of criminal trespass of a habitation, a Class A misdemeanor, assesses punishment at 34 days confinement in Van Zandt County Jail, orders him to pay a $500 fine, court costs of $270, and reimbursement fees of $535. And the court awards him 34 days credit towards his sentence for the time that he has spent in jail on that cause. In cause number CR 24-183, the court finds counts 1 through 5 in the state's amended motion to be true. The court hereby adjudicates the defendant's guilt, convicts the defendant of the second-degree felony offense of burglary of a habitation. The court hereby revokes the defendant's community supervision, finding that he's violated terms and condition. Court assesses punishment at 8 years confinement. The Texas Department of Criminal Justice and orders him to pay the balance of his financial obligations. And the court awards the defendant 338 days credit towards his sentence for the time that he has spent in jail on this cause. All right, Mr. Jenkins, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. We're going to take your fingerprint and then you'll go have a seat. Mr. McInturf. This cause number CR 26-4, State versus Robert Walter McInturf. All right, Mr. McInturf, if you'll raise your hand, I'll place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So if you go ahead and raise your hand. All right, thank you. Go ahead. Give me just a moment. Paperwork is coming up. All right, Mr. McInturf, you've been charged by indictment, or actually by information, with a collision involving damage to a vehicle greater than or equal to $200. Is this a reduction to? Says that he on the docket, it says it's aggravated assault with a deadly weapon, but this says
Yes, Your Honor.
information for Class B, but it's the same offense. No, actually, this says CR 2640. This says CR 264. See,
Yes, Your Honor. I filed a CNI yesterday too.
All right, there's-
Effectively.
there's a 0 that's after the 4 I didn't see. Okay. All right, so Mr. McInturf, you were charged with aggravated assault with a deadly weapon, a second-degree felony, in cause number CR 26-4. The state's moving to dismiss that today based on insufficient evidence. You've also been charged by information in cause number CR 26-40 with the Class B misdemeanor offense of collision involving damage to a vehicle greater than $200, a Class B misdemeanor, which carries a range of punishment of not more than 180 days, and a possible fine not to exceed $2,000. I see that there's a plea agreement in your case that you would be pleading guilty to that in exchange for the state's plea agreement and recommendation of 179 days confinement in the county jail, for which you would receive 179 days credit. In addition, you would be ordered to pay a $500 fine, $270 in court costs, and $515 in reimbursement fees. And the state is asking the court to dismiss FC 26-27, which is a criminal mischief. Is that your understanding of the plea agreement today, Mr. McInturf?
Yes, Your Honor.
All right, Mr. McInturf, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Schmidt. Are you pleased with him as your attorney?
Yes, Your Honor.
Do you understand everything that you've read and signed?
Yes.
Do you have any questions?
No, sir.
Mr. Schmidt, do you believe your client to be competent to enter into an agreement? And if so, he's doing it intentionally, knowingly, and voluntarily after understanding his legal rights?
Yes.
All right, Mr. McInturf, to the charge of collision involving damage to a vehicle greater than $200, how do you plead?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, Your Honor.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, Your Honor.
Court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulated evidence?
No objection.
Evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from state?
Your Honor, just so that the record's clear on everything, the both of these cases came out of the same course of conduct. We didn't feel, after speaking with some witnesses, that the aggravated assault, that the evidence was there, obviously, so we refiled it. The reason it's being pled to the misdemeanor B is because I didn't think that was an actual lesser included, which is why the new cause was filed. However, in addition to that, Your Honor, there was no, in the aggravated assault case, since the misdemeanor was filed yesterday, there was no victim impact statement or restitution request returned in that, and it's the same, all of the same actors involved.
Okay, thank you. I appreciate that. That does help. Anything further from the defense?
No, sir.
All right, court's going to review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant. Court will follow the plea agreement. Court hereby convicts the defendant, Robert Walter McIntyre, of Class B misdemeanor collision involving damage to vehicle. Assesses punishment today at 179 days in county jail. Awards Mr. McIntyre 179 days credit towards that sentence. Court also assesses a $500 fine, court costs of $270, and reimbursement fees of $515. Court also dismisses under section 1245, clause number FC 26-27, criminal mischief. Mr. McIntyre, if you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you are fingerprinted, then you'll return to the sheriff.
Thank you.
It's John.
Is it time for your interpreter?
I don't know where Mr. Manny, oh, there he is. I see. Good afternoon, Ms. Bill. Yes, ma'am. I have you now.
Hey.
All right, Ms. Bill, I'm going to have you raise your hand so I can place you under oath. Do you swear or affirm that you will make a true translation of the statements of court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? If you'll go ahead and state your name and your license number. All right, court calls, cause number CR 23-62, State of Texas versus Ivan Molina Hernandez. Mr. Molina Hernandez is before the court today on the state's motion to adjudicate. Any announcements from the defense?
Yes, Judge. Previously have retained a investigator who speaks Spanish to assist in confirming and documenting the reason for Mr. Molina Hernandez's absence from probation, being that he was in the hospital in Dallas County. We have met with the investigatory agency and discussed the facts of his hospitalization. But as of last week, when I emailed the investigator retained by Mr. Molina Hernandez, we have not received any information or updates on his case. Through my discussions today with Mr. Molina Hernandez, he's expressed understandable frustration with being unable to confirm and get back on probation after his lengthy, approximately 5-month incarceration on this hold. I explained to him that the two options were that we were to go forward with the hearing or continue waiting for this documentation. And I believe prior to us being called up, that his preference would be to stay the course and continue trying to get the documentation of his hospitalization in Dallas County.
So the defense is asking for continuance of the hearing.
Judge, I would like to confirm, due to the language barrier, that is what Mr. Molina Hernandez would like to do. As I said, we did have some conversations where he expressed frustration with the delay.
Ms. Bill, would you ask Mr. Molina if he understands Mr. Manning's announcements and if he can state to the court if he is asking for this case to be continued for an additional 30 days? It is possibly get the documentation for his defense, or would he like to proceed with a hearing before the court?
De una vez.
Proceed with a hearing today?
Yes.
Okay, go ahead and have a seat and we will bring you back up shortly.
Okay.
Actually, Jonathan, him right there, just
Oh, hey.
go ahead and put that back on. We weren't anticipating a contested hearing,
No, we're not, Judge.
so I don't have an interpreter lined up for a contested hearing. That person would have to come in person, be here. So Ms. Bill is not able to do that. So
Yes,
the
Judge.
best that I could do is reset him to May 28th. And if he has his paperwork for the defense, great. If he doesn't, then we can go forward with a contested hearing on the 28th. But the court will need to be made aware so that it can make arrangements to get a certified court interpreter to assist the defendant in the proceeding.
Judge, based on my conversation with Mr. Molina Hernandez and his assertion to the court that he would like to proceed, we would request that on the 28th that we go forward and have a contested motion to revoke with an interpreter present.
That is noted for the record, and the court will make that arrangement. Court hereby recess Mr. Molina's case to May 28th at 1:30. All right, thank you, Ms. Bill. I appreciate you being here. Yes, ma'am. Good, Steve.
Here, Bill.
Dylan Garrison. All right, court calls number CR 26-10. State of Texas versus Dylan Dale Garrison. And Mr. Garrison, if you'll raise your right hand, I'm placing you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thanks, sir. You can lower your hand. Your name is Dylan Dale Garrison, is that correct?
Yes, Your Honor.
Mr. Garrison, are you a United States citizen who reads, writes, and speaks English?
Yes, Your Honor.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with him as your attorney and the work that he's done?
Yes, sir.
You understand everything that you've read and signed today as part of your plea agreement.
Yes, sir.
Do you have any questions before we go further?
No, sir.
Mr. Schmidt, do you believe Mr. Garrison to be competent? And if so, that he is entering into this agreement intentionally, knowingly, and voluntarily after understanding his legal rights, including the advantages and disadvantages of a deferred adjudication plea?
Yes, sir.
All right, Mr. Garrison, you are charged by indictment with a third-degree felony offense of possession of a controlled substance in penalty group 1, greater than 1 gram, less than 4 gram. A third-degree felony is punishable by not less than 2 years in prison or more than 10 years in prison, and a fine up to $10,000. The plea agreement in your case appears to be, upon you pleading guilty, the state's recommending that the court consider the evidence, not convict you, place you on deferred community supervision for a period of 4 years, assessing a $1,000 fine, restitution of $180, and as a condition of your community supervision, you would have to attend the Safe Peak program. In addition, you would have court costs of $290 and reimbursement fees of $520. As part of this plea agreement, the state is also, they've tendered a motion to dismiss in cause number 2025-649. That appears to be in the county court of law. Could we transfer that up? No.
It has not been transferred, Judge. If the court would like, I have to take a hard copy to Judge Winters for his signature.
Please do. I'm going to go ahead and sign this one because otherwise it won't let me sign the rest of the documents.
Yes, sir.
But I think it'd be good to have him sign it as well.
Yes, sir. Can do.
Or ask him if he's okay with me signing that. All right. So that's your understanding, Mr. Garrison, what you're asking the court to approve?
Yes, Your Honor.
All right. Understanding all of those things, how do you plead to possession of a controlled substance in penalty group 1?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing the crime?
Yes, Your Honor.
Anyone threatened you, forced you, or pressured you to plead guilty?
No, Your Honor.
Or does accept a defendant's plea of guilt? Mr. Schmidt, any objection to the evidence?
No objection.
Evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
From the defense?
No, sir.
All right, court's going to review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. Court will follow the plea agreement today. The court hereby defers the finding of guilt for Dylan Dale Garrison, places him on community supervision for a period of 4 years, orders him to pay a $1,000 fine, $180 in court costs. $180 of restitution, $290 in court costs, $520 in reimbursement fees. Orders him to attend the safety program as a condition of his community supervision. The court will take into consideration on Judge Winter's consent, cause number 2025-649. Mr. Garrison, you hereby remanded to the custody of the sheriff. Sergeant Martinez is going to take your fingerprint behind you. All right.
Yes, Your Honor.
Mr. Manning, are you ready on Douglas, Maine?
Judge, I am. I also was just informed that I believe Mr. Cody Gray is logging in. He was at a doctor's appointment this morning, which was why he was unable to be contacted.
He's not in there yet, so.
Okay. Yes, Judge. Ready on Mr. Maine.
Douglas Ray, Maine, CR 26-2, CR 26-3. All right, you are Douglas Ray Maine Jr., is that correct? Yes. Mr. Maine, if you'll raise your hand, I'm going to place you under oath. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God. All right, Mr. Maine, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney?
Yes.
Do you understand everything that you've read and signed in your plea agreement?
Yes.
Do you have any questions? Mr. Manning, do you believe your client to be competent to enter into this agreement? If so, that he's doing so intentionally, knowingly, and voluntarily after understanding his legal rights?
Judge, he is competent, and I believe he's entering his plea intentionally, knowingly, and voluntarily.
All right, Mr. Maine, you are charged by indictment in cause number CR 26-3 with the state jail felony offense of theft of property greater than $2,500, less than $30,000. State jail felony is punishable by no less than 6 months confinement in a state jail prison and no more than 2 years, and a fine up to $10,000. I see the plea agreement in your case is upon you pleading guilty. The state is recommending that your punishment be assessed at 2 years confinement in state jail, a $1,000 fine, plus court costs of $290 and reimbursement fees of $20. And the state is asking the court to dismiss DA 2024-1165, which is an evading arrest or detention with a vehicle. Mr. Manning, how much credit time would your client receive?
Judge, he has 178 days credit, and I may note, Judge, that there's also a motion to dismiss in both counts of CR 26-2. So count 1 and 2 of CR 26-2 are also being dismissed as a part of this plea agreement.
I don't see it as part of the plea agreement formally, but I do see the motions to dismiss filed by the state, but they're not included in the plea bargain portion of the judgment in CR 26-3. But for the record, the state has filed a motion to dismiss clause number CR 26-2 with regards to counts 1, 3, counts 1 and 3. Is that your understanding? All right, actually it says count 2 and then count 1, and then, yeah, count 3. So all 3 counts. says CR 26-3, CR 26-2*1, CR 26-2*2.
Judge, my understanding it was only 2 counts in that indictment.
Yes, Your Honor, there should have been 2 counts in CR 26-2 and pleading here. in
Here in 3. Okay.
Yes,
Yeah, so pleading in 3 and then dismissing counts 1 and 2.
Yes, Judge.
CR 26-2. Are there any other counts remaining in that CR 26?
no, Your Honor, that completes that indictment.
Okay. So the court does note again for the record the state's motion to dismiss in cause number CR 26-2, counts 1 and 2. All right, so Mr. Maine, that's your understanding of the plea agreement, what you're asking the court to accept?
Yes.
All right. So Mr. Maine, at this time, I'd ask you, how do you plead to theft of property greater than $2,500, less than $30,000?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
Or does accept the defendant's plea of guilt? Mr. Manning, any objection to the evidence?
No objection as offered.
The evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, just that in CR 26-2, no victim impact statement was returned, and in CR 26-3, no victim impact statement or restitution request was returned.
Thank you, Charlie. Anything from the defense?
Rest in close, Judge.
All right, court's reviewing the evidence. All right, the court having reviewed the evidence, finds enough evidence to convict the defendant. The court will follow the plea agreement. Court hereby convicts the defendant of state jail felony offense of theft of property greater than $2,500, less than $30,000. Assesses punishment at 2 years confinement. The state jail division of TDC orders the defendant to pay a $1,000 fine, court cost of $290, and reimbursement fees of $20. The court does dismiss unfiled DA case number DA 2024-1165, evading arrest or detention with a vehicle. Court awards Mr. Maine 178 days credit towards his sentence, time served in this cause. The court does grant the state's motion to dismiss in cause number CR 26-2 for both counts 1 and 2. All right, Mr. Maine, you hereby remanded to the custody of the sheriff. We're going to take your fingerprint. Good luck to you, sir. Who are you ready on next, Mr. Maine?
Judge, next ready on Edward Drummond.
Mr. Drummond. It's cause number CR 26-22, State of Texas versus Edward Joseph Drummond, and Mr. Drummond is set for pretrial today.
Judge, after review of the discovery, we have no contested pretrial issues. I do believe that there is a mitigating exculpatory statement that's been made. I have not been provided access to, but the DA's office did confirm they do have that, and we would be getting access to that. Additionally, Judge, we've been made an offer to resolve the case that involves safety as a condition of probation. However, my client has rejected that and requests to be set for jury selection.
All right, and what was the official offer or the complete offer?
Your Honor, we never got down to specifics, but it would have been a deferred probation with safety as a condition.
All right, so you want to go right to jury selection, Mr. Manning?
Judge, that is what Mr. Drummond requested.
And he understands that if he decides, after today, he wants to take that deferred probation and go to safety, that the court, can reject his request.
Judge, I don't remember if I specifically had that conversation with him today, but we have discussed previously the court's policy that once we get to, or once we get past announcing we're ready for trial, the court may or may not accept any additional negotiations.
You understand that, Mr. Drummond?
So,
Okay. All right, the court finds that Mr. Drummond, having requested, jury trial, places him on the jury selection docket beginning May 4th. Once he gets into the, top 10, Mr. Manning will notify you and Mr. Drummond.
thank you, Judge.
Who's next, Mr. Manning?
Judge, can we check and see if Mr. Gray is in queue?
He is. All right, Mr. Gray, can you see and hear me okay?
Yes, sir.
All right, I'm gonna go ahead and call your case, all right? This is cause number CR 19-175, State versus Cody Allen Gray on the state's motion to adjudicate. Any announcements, Mr. Manning?
Judge, we would request additional continuance on this case as Mr. Gray is incapacitated due to his injuries. I have not had an opportunity to speak to Mr. Gray prior to this to see how long he will be off his feet, but if I may have at least additional 1 month for me to coordinate with him and see what his recovery time looks like.
All right, court will grant the request. The court hereby recess Mr. Gray's motion to adjudicate to May 28th. At 9 a.m. All right, so Mr. Gray, stay in contact with your attorney, Mr. Manning, and also your bondsman, okay?
Yes, sir.
All right, make sure you're also complying with your probation officer, because you're still on probation, so make sure that they're in the loop on everything that's going on, okay?
Yes, sir.
All right, thank you for zooming in today. I know that it's been kind of difficult for you, so I appreciate that.
All right. Thank you so much.
You're welcome. You have a good day.
Sure.
Who's next, Mr. Manning?
Judge, if we could have Ms. Carter.
I don't have any more pleas. Is it a plea agreement?
Judge, we have the agreement, however, the time calculation. County.
All right, court will reset Ms. Carter then for plea on May 12th.
Judge, I will not be available on May 12th.
You're out May 12th. Let's see, I'm gonna do May 26th.
Yes, Judge.
Actually, that's a Tuesday. We'll just do May 28th.
Yes, Judge.
We'll keep you on a Thursday.
Judge, we're awaiting paperwork for the. Um, And the paperwork that I do have is for folks that aren't here.
Okay. All right, court will stand in recess. Mr. Schmidt, are you ready on Mr. Harrison? Is he not here? So Valencia. All right, court's gonna stand in recess until the pleas are prepared and the additional inmates are brought over from the justice. All right, Mr. Schmidt, who are you ready on?
Jay Harris.
Mr. Harrison? Says cause numbers CR 24-137, CR 26-28, State versus J. Randall Harrison. Mr. Harrison has two cases, one motion to adjudicate, and then a new charge of possession of a controlled substance. The group one, a second degree felony that's set for arraignment. Go ahead.
Judge, on the CR 26 cause number, could you give me that last three digits?
It's 00028.
On the new offense, we will waive reading of the indictment. His name is spelled correctly. Enter a plea not guilty. Ask for a pretrial setting on that one. Now it's not ready on the MTR and ask those to be carried together for a pretrial on the new offense.
All right, court finds that Mr. Harrison has waived the formal requirements of arraignment, enters his plea of not guilty into the record and cause number CR 26-28. Court will set Mr. Harrison for pretrial hearing. On June, you want June 2nd or June 16th?
June 2nd, fine, Judge.
Court sets Mr. Harrison for June 2nd in each cause. Court will carry the motion to adjudicate with the new case.
Yeah, that's it.
Court calls cause number CR 24-81, CR 24-82, State versus Ezekiel Alejandro Valencia. Mr. Valencia is set for state's motion to adjudicate each cause.
Judge, I think Mr. Valencia has been in Kaufman County continuously. I think we just got him back to our facility here recently. I've been in negotiations with Mr. Hartwell. I think we're pretty close to a resolution, but we're going to ask for one final setting on his motions. I think we'll resolve it and come back.
Any objections, Mr. Hernandez?
No, Your Honor.
All right, court grants the request. That's Mr. Valencia on May 28th. Each cause. Looks like I just received papers on Mr. Barr. See, he has two cases. Let me see. That's all of your cases, correct? Got Mr. Manning's name on here, but I can double check. Mr. Manning appointed on April 8th. Oh, all right, court's going to stand in recess, give Mr. Manning time to counsel with his clients and stay to finish plea papers. Court's in recess. All right, Mr. Manning, who would you like next?
And if we can start with Mr. Baker.
Mr. Baker, come on up. Baker. Michael Lynn Baker, CR 26-7. All right, Mr. Baker is set today on pretrial.
Yes, Judge.
If he needs to sit, he can just have a seat. Right there's you. Either one. Yeah, that's perfect.
Judge, we have no contested pre-trials at this time. We request to be set on the docket call announcement.
All right, the court finding there are no contested pretrial issues sets Mr. Baker for docket call. You said you're gone on the 12th, correct?
Correct, Judge.
We'll set Mr. Baker on the 28th.
Yes, Judge. Next, ready on Mr. Bates.
Christopher Robin Bates, CR 25-118. All right, Mr. Bates is set today. A motion to suppress it.
Judge, no, this is a contested motion to adjudicate or revoke. However, we reached an agreement with the state for 3 TVCJ and would request to be set for a plea on May 28th.
Can't do it today.
No, Judge, they were unable to get the paperwork together, and I received the offer today in order to convey it to him today.
All right, court sets Mr. Bates for plea. May 28th.
Judge, next ready on Ms. Hill, Jennifer Hill, that will be a plea.
Jennifer Aaron Hill, CR 26-13. Also in cause number FC 26-26. Seal, if you'll raise your hand, I'm going to place you on oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, your name is Jennifer Aaron Hill, is that correct?
Yes, Your Honor.
Ms. Hill, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Manning. Are you pleased with Mr. Manning and the work that he's done?
Yes.
Do you have any questions about the paperwork or anything else? Mr. Manning, do you believe Ms. Hill to be competent to enter into the agreement, and if so, that she's doing it intentionally, knowingly, voluntarily after understanding her legal rights, including the advantages and disadvantages of a deferred adjudication plea?
Judge, I have explained the advantages and disadvantages of deferred plea. She understands those, and I believe she has entered this plea intentionally, knowingly, voluntarily. The judge, I believe she's been competent and she has been able to assist in her defense throughout this process.
All right, Ms. Hill, in cause number CR 26-13, you are charged with the felony offense of accident involving injury. What's the level of that?
Judge, that is a special range of punishment of 2 years up to 5 years TDCJ under the Transportation Code.
Minimum 2, maximum 5.
That is correct, Judge, and a maximum of $5,000 fine.
So, Ms. Hill, do you understand that full range of punishment?
Yes, Your Honor.
I see that the plea agreement in your case is that you would be pleading guilty to that crime in exchange for the state's recommendation that the court defer a finding of guilt, means not convict you, for you to be placed on 3 years community supervision, a $1,000 fine, court cost of $290, reimbursement fees of $520, and restitution of $97. And as part of the case, the state is agreeing to dismiss cause number FC 26-26. Is that your understanding of the plea agreement, what you're asking the court to approve?
Yes, Your Honor.
Understanding the range of punishment in the plea agreement, Ms. Hill, how do you plead to accident involving injury?
Guilty, Your Honor.
Are you pleading guilty to that crime because you are guilty of committing that crime? Has anyone threatened you, forced you, or pressured you to plead guilty?
No, Your Honor.
All right, court does accept the defendant's plea of guilt. Mr. Manning, any objection to the evidence?
No objection is offered.
All right, the evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the statement?
The victim impact statement was sent out but not returned. The
Thank
state
you.
is in compliance.
Thank you, Mr. Hernandez. Anything further from the defense?
Nothing from defense, Judge, other than the fact that there is an agreement to take into consideration the FC case number, and I believe there is a $97 restitution to the victim in this case.
Thank you. All right, court's going to review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant. Court follows the plea agreement today. The court defers a finding of guilt, places the defendant on deferred community supervision for a period of 3 years, orders the defendant to pay a $1,000 fine, restitution of $97, clause number FC 26-26, orders court costs of $290 and reimbursement fees of $520. Court also dismisses FC 26-26. All right, Ms. Hill, you're hereby remanded to the custody of the probation department. I'll have you step over to be fingerprinted, and then the probation officers may talk to you.
Right next on Mr. Ryan Johnson.
Yes, sir. Please. Right, this is cause number CR 24-194, State versus Ryan Parker Johnson. All right, Mr. Johnson, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. All right, Mr. Johnson, you're here today on the state's motion to adjudicate. The state has filed a motion to withdraw their motion to adjudicate and to continue you on community supervision. You would be ordered to serve 75 days in the county jail as a condition of your community supervision. You would receive credit for 75 days of time already served. Your probation conditions would also include an additional $500 for the attorney fees that were generated because of this motion. You understand that if the court grants this today, that 75 days in jail, you would not get credit for that in the future should you receive another motion and be revoked. Do you understand that?
Yes, sir. Yes, Your Honor.
All right, Mr. Johnson, has anyone threatened you, forced you, or pressured you to enter into this agreement?
No, sir.
All right. Court hereby grants the state's motion to withdraw. The court hereby amends the conditions of community supervision for Mr. Johnson. Includes an additional $500 in attorney fees in order for him to serve 75 days in jail as a condition of community supervision with credit for time served from May 7th, 2024 to July 20th, 2000. Thank you, Mr. Mr. Johnson.
Judge, next ready on Jodine Lewis.
Ms. Lewis. This is cause number CR 22-357, State versus Jody Walters Lewis. All right, Ms. Lewis, if you'll raise your hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. All right, Ms. Lewis, you were previously before the court on March 9th of 2023. On that day, you pled guilty to possession of a controlled substance. The court heard the evidence. The court assessed your punishment at 8 years confinement in prison. Court also assessed a fine of $2,500. The court then suspended that sentence and placed you on community supervision for a period of 8 years. It was during that period that the state has filed its motion to revoke your community supervision, and they have alleged 6 counts of violations. Have you had enough time to review that with your attorney, Mr. Manning?
Yes, sir.
Are you pleased with Mr. Manning as your attorney?
Yes, sir.
Do you have any questions about the paperwork or anything else?
No, sir.
All right, I see that there is a plea agreement in your case upon you pleading true to those counts. The state is offering that your community supervision be revoked, that your punishment be assessed today at 6 years confinement in the Texas Department of Criminal Justice. The court would also be ordering you to pay the balance of your financial obligations, which includes the remainder of your fine and your reimbursement fees. How much credit time would Ms. Lewis receive?
Judge, we were able to come to an agreement of 499 days credit.
499?
Yes, Judge.
All right, and part of that agreement, Ms. Lewis, the court would give you your back time credit of 499 days. Is that your understanding of what you're asking the court to approve?
Yes, sir.
All right. Mr. Manning, do you believe that Ms. Lewis is competent to enter into this agreement? And if so, that she's doing it intentionally, knowingly, and voluntarily after understanding her legal rights?
Yes, Judge.
Does she waive the formal reading of the state's motion?
She does.
She intend to plead true to all counts?
She does.
All right, Ms. Lewis, at this time, how do you plead to counts 1 through 6? Are those counts true or not true?
True.
Has anyone threatened you, forced you, or pressured you to plead true to any of those counts?
No, sir.
All right, the court will accept the defendant's plea of true. Any objection to the evidence, Mr. Manning?
No objection as offered.
All right, the evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, thank you.
Further defense?
Rest and close, Judge.
All right, based on the testimony, the court finds that Ms. Lewis has violated the terms and conditions of her community supervision. Court finds counts 1 through 6 to be true. Court follows the plea agreement today. The court revokes her community supervision, assesses punishment at 6 years confinement in the Texas Department of Criminal Justice, orders her to pay the balance of her financial obligations. Court also awards Ms. Lewis 499 days credit towards her sentence for the time that she has spent in jail on this cause. Ms. Lewis, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you be fingerprinted. Good luck to you, man.
Judge, next ready on Mr. Jacob Myers.
All right, court calls cause number CR 23-30, State versus Jacob Wyatt Myers. Mr. Myers, if you'll raise your hand, I'm gonna place you on oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Thank you, sir. You can lower your hand. All right, Mr. Myers. Get your paperwork here. All right, Mr. Myers, you were in this court on August 22nd of 2023, wherein you pled guilty to a third-degree felony offense of assault of a family or household member with previous conviction. Court heard the evidence, found that there was enough evidence to convict you. However, the court followed a plea agreement between you and the state. The court placed you on deferred community supervision for a period of 5 years and also assessed a fine. It was during your period of community supervision that the state filed its motion to adjudicate and revoke, in which they alleged 13 various counts of violations. Have you had enough time to review that document with your attorney?
Yes, sir.
You understand everything that you've read and signed today?
Yes, sir.
Are you pleased with Mr. Manning as your attorney?
Yes, sir.
Do you have any questions about anything?
Sir.
Mr. Manning, do you believe Mr. Myers to be competent to enter into the agreement, and if so, that he's doing it intentionally, knowingly, voluntarily?
Judge, he is competent. I believe he is entering into that agreement intentionally, knowingly, and voluntarily.
What kind of credit time has he acquired?
Judge, he will have 20 days credit.
20 days?
He originally had some additional days that were used up as a condition of probation for a previous motion.
All right, so Mr. Myers, I see that your plea agreement today, upon you pleading true, the state's recommending that you be convicted of the offense, that your community supervision be revoked, and that you be assessed 2 years confinement in prison, with you being ordered to pay the balance of your fines, court costs, and fees, and you would receive 20 days credit towards that sentence. Is that your understanding of the plea agreement?
Yes, sir.
All right, Mr. Myers, at this time, I would ask you, how do you plead to counts 1 through 13? Are those counts true or not true?
True.
Has anyone threatened you, forced you, or pressured you to plead true to any of those counts?
No, sir.
Court will accept the defendant's plea of true to each count. Mr. Manning, any objection to the evidence being admitted?
No objection as offered.
All right, court admits the evidence. Court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, thank you.
From the defense?
Judge, I just would briefly point out that while Mr. Myers recognizes he violated each and every one of those conditions, he did want the court to know that he attempted to do the class for count 13, but was unable to successfully do so within the time period required by the court under the restrictions that he was under.
Thank you, Mr. Manning. All right, the court's going to review the evidence. All right, the court finds that based on the plea of true that Mr. Myers has violated the terms and conditions of his community supervision, the court finds counts 1 through 13 to be true. The court will follow the plea agreement today. The court hereby convicts Jacob Wyatt Myers of assault of a family or household member with previous conviction. The court revokes his community supervision, assesses punishment at 2 years confinement in the Texas Department of Criminal Justice, orders him to pay the balance of his financial obligations, and awards him 20 days credit towards his sentence for the time spent in jail. Mr. Myers, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you be fingerprinted with Sergeant Martinez.
Finally, Judge, I have Mr. Joshua Ibarra.
Cause numbers CR 25-88, CR 25-263, State of Texas versus Joshua Andrew Ibarra. Just one moment here, Mr. Ibarra. Mr. Ibarra, cause number CR 25-88. For the court on May 27th of 2025, last year, wherein you were convicted of the offense of failure to comply with sex offender duty to register for life, a third-degree felony. Punishment was assessed at 8 years confinement in prison and a $750 fine. The court suspended that sentence and placed you on community supervision for a period of 5 years. It was during that period that the state filed its motion to revoke and alleged 12 separate counts of allegations of violations. Have you had enough time to review that document with your attorney, Mr. Manning?
Yes.
Do you have any questions about anything that you've read or signed today? No. Are you pleased with Mr. Manning as your attorney?
Yes, sir.
Mr. Manning, do you believe that Mr. Ibarra is competent to enter into the agreement? And if so, that he's doing it intentionally, knowingly, and voluntarily after understanding his legal rights?
I do, Judge.
All right, Mr. Ibarra, I see that this case, plea agreement is, the state has filed a motion to dismiss in CR 25-263. That's the case. That's the failure to comply with sex offender duty to register. CR 25-88. Plea agreement is upon you pleading true. State's recommending that your community supervision be revoked and you be sentenced to 4 years confinement in the Texas Department of Criminal Justice with the balance of your fines, court costs, and fees. How much credit time does Mr. Ibarra have?
There's agreement for 382 days.
So, Mr. Ibarra, you would also receive that credit towards your sentence for time that you've already spent in jail. Is that your understanding of the plea agreement?
Yes.
All right. Mr. Manning, does your client waive the formal reading of the state's motion?
He does, Judge.
All right. Mr. Ibarra, how do you plead to counts 1 through 12? Are those counts true or not true?
True.
And you're admitting that you committed all of the acts in those of your own free will. No,
Yes, sir.
meaning no one's pressured you, forced you in any way to plead true to any of those counts.
Yes, sir.
All right, court will accept the defendant's plea of true to counts 1 through 12. Mr. Manning, any objection to the evidence?
No objection as offered.
The evidence is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, sir. Thank you.
Anything further from the defense?
Rest in close, Judge.
All right, based on the evidence before the court finds that the defendant has violated the terms and conditions of his community supervision. The court finds counts 1 through 12 to be true. The court hereby follows the plea agreement today, revokes the community supervision of Mr. Ibarra. Court assesses punishment at 4 years confinement. The Texas Department of Criminal Justice orders him to pay the balance of his financial obligations and awards him 382 days credit towards his sentence for the time spent in jail on this cause. Mr. Ibarra, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. So I'm gonna have you step over to be fingered. That concludes the court's criminal docket. There is nothing further, then we are adjourned.